8:30 p.m. is the time that was given up by Chief Justice David Maraga after the adjournment for about an hour. But back in studio, lawyer Mudomi Thiankolu once again joins me. The final submissions are expected this afternoon, and of course we'll get word or submissions from the friends of the court. What do we expect?
Basically, I would expect Professor Wainaina would pitch why he either supports or opposes the petition. For the Attorney General, his role will be confined to what is the meaning and the implications of the decision made by the Court of Appeal to the effect that the results announced at the polling station and collated by the constituency returning officer are final. It's a very limited scope for the Law Society. They will be addressing the court on Section 83 of the Elections Act, which we said earlier says when an election is not to be nullified. Yes.
But looking at 2013 and now, I will just want to touch on the time limit that has been given there for the interested parties and the friends of the court. Of course, less time than what was witnessed in 2013. What really could be the basis for a bench to decide that they want this amount of time for this party? What are the dynamics?
The dynamics in 2013, the amicus curiae and the interested parties took a lot of precious judicial time addressing issues that maybe were better left to be addressed by the real disputants in the case. And I would imagine part of the thinking, actually, my own view is that the court has only given them some token airtime just to address the court, because on both the issues that the Attorney General and the Law Society will be addressing the court, there have been more than enough submissions on those two issues from both sides. I suspect the court just didn't want to appear to be shutting anyone out because of the controversies surrounding 2013. So my view is there will be little value they will earn, and there is nothing they will say anyway, which the primary parties, that is to say, Raila Odinga and the IBC and Uhuru Kenyatta, have not already submitted on. And I've seen their submissions. They have actually addressed those issues very well. Yes.
Are we likely, what really could make this a prolonged case or it into the judicial time, like you say, from what we expect this afternoon? Is there anything that will hinder the court from adjourning today evening for the judges to retire?
I don't see anything ruling out surprises from the scrutiny that is taking place at Milimani Law Courts and Anniversary Towers. And what I love about this time is that the court will have at least 2 clear days to reflect and give us perhaps a more cogent decision than the time they had in 2013.
You are a lawyer who's dealt a lot with the election petitions in this country, and looking at the presidential petition in 2013 and how it was conducted, the whole procedures, and looking at how things have been this time round, what has been a take-home for you?
For me, the take-home is how the court this time round has made deliberate effort to avoid the legal and procedural technicalities approach. The other thing I've noted is the exceptional amount of time spent by especially the petitioners to show the court that it was wrong in 2013. I don't know whether that should actually have been part of the agenda or part of the strategy, but I've seen a lot of effort being committed to that. Of course, there has been a lot of preparation this time around, and like 2013 when the court was relatively new, without much experience. So for me, the take-home is, based on what has happened so far, irrespective of what decision the court makes, it will be a much, much richer decision. It is a much, much richer process, more structured than 2013.
On Friday, we expect that decision to be made. What are the likely outcomes?
There are only 2 possible outcomes. Either allowing the petition, which would mean there will be a presidential election in 60 days according to our constitution, or dismissing the petition. If it is dismissed, it means His Excellency Uhuru Kenyatta will be sworn in for his 2nd term, and we'll wait for the next round of elections.
I want us to go back to some of the arguments we've seen in court and the whole procedure from yesterday when the legal team for NASA took the stand to when this particular, when the third respondent, actually, legal team for President Uhuru Kenyatta took the stand today. Earlier on, we were talking about what would be the grounds to invalidate an election because that came out from some of the arguments that we saw there. And there was a question of an election cannot be invalidated if a voter did not raise concern or they did not feel disenfranchised. Can we expand on that? What's the legal borrowings or the articles that we're following on this, and what are the principles on which an election can be invalidated?
What our viewers should learn is that in an adversarial legal system like ours, there is a natural human tendency, and I must say both the lawyers for all the sides have done an exemplary job. In my view, both teams have done extremely well. Having said that, it must be appreciated that in an adversarial system, each side will try to make an argument that favors their version of the narrative, so that you expect the petitioner will conveniently put to you